Good morning, namaskar, sasyakal, and adab. This is my 277 video, and this will cover an issue of an allegation or that Union of India has been calling us licensee. Now, what does this word licensee and from which act or section does it come through? As admitted by the government or Union of India that we bungalow owners are holder of occupancy rights on old grant terms were licensees. Then we must read this definition in the Act of Easement Act 1882, same as per section 52. It very clearly reads a license or a licensee is defined where one person grants to another or to a definite number of other persons a right to do or continue to do or in or upon the immovable property of the grantor. Something which would, in the absence of such right, be unlawful, and such right does not amount to any easement or any interest in the property. The right is called a license. Now, this clearly states that Union of India had allowed us or our predecessors to do something on this land, which is immovable property, as per Section 54 of the Transfer of Properties Act 1882. Now, but if you read the Easement Act 1892 and you read Section 60, it reads license when revocable. A license may be revoked by the grantor unless A. It is coupled with a transfer of property and such transfer is in force. B. The license acting upon the licensee has executed a work of permanent character and incurred expense in the execution. Now, we would like to state that the licensee, which we are called, executed a work of permanent nature, oblique character, and for the same incurred expenses for which the government is compensating. So, we licensee for the same movable property created a built up building estate which is accepted by the Union of India, and it also accepts that the bungalow owners were allowed to construct or build a bungalow on the land granted by government. Or does the government plead anywhere that the land was granted along with a built up building or estate? The government, ever since the making of Cantonment Act 1864, has been accepting that we are the owners of the house or the built up house and not the land, even if we go by the 1864 Act. Now, simultaneously, if we come to the Cantonment Land Administration Rules 1925 or 1937, as per Rule 10 CLA 1937, reproduced in Rule 4 of 1925, every transfer of right or interest in land in the cantonment registered under Section 54, 59, 107, or 123 of the Transfer of Properties Act, of which information has been sent to him under subsection. Now, what does subsection say? Let's read section 287 of the Cantonment Act 1924. Or by the board when such transfer necessitates an alteration of the entries in any of the column of the register. So let's have our GLR. That is why I say read section 10 or section 45 sub rule 3. In the same CLA rules in 1937, the executive officer shall forward to the MEO a monthly statement showing, in addition to the information required by sub rule 2, every transfer of right or interest in immovable property outside bazaar registered under section so and so of the TPA Act, and which information has been received under subsection 2 of section 287 of the Cantonment Act, and report of every transfer of right or interest in immovable property outside bazaar which has come to the knowledge but of which no report has been made. The said statement shall be accompanied by a lessee's plan or relevant documents. Now, here, friends, I'm being very serious. It's using the word outside bazaar, and who? The cantonment magistrate under these rules, 1937. So, who's the custodian of our land? It was never the MU, it was the cantonment executive officer. Now, let's come back to section 60, subsection A, the Easement Act 1892. It reads that where the licensee is coupled with the TPA, it becomes irrevocable license. Anything left? Union of India has been enforcing the said statement that we are to be called a licensee. This is enough for the court to decide that the license cannot be revoked and the peaceful possession of our predecessors and us can never be taken by Union of India. It's very simply written in the law that the word licensee of two landholder is specified in these various cantonment land administration rules, military manuals, like where does it does not allow the army unit divisions to construct any building other than temporary structures. So these section rule 15 which restricted sale of land, but these are classified for class A lands. But now the interpretation has gone to that these rules are applicable on B3 lands. Nothing ever the Union of India's council or department has brought on record any kind of documentary evidence to show how they became true owners at any given stage for my cantonment or could be for your cantonment. Now, if we read the GLR only, these words are there. So, friends, the definitions have been explained. What does CLA rules 1937 A1, A2, B3 define? It clearly now, once again, if I use, it is using some very peculiar words which can be challenged, held, or may be presumed. So, presume, held, both are challengeable. To be held under provisions of the cantonment code. So a document has to come under the cantonment code, it says. Are any of our documents coming? The register which the department shows of the cantonment code, it shows all leasehold bungalows. Writing that we are an old grant, yet it subjects us into the leasehold. Now, or under any executive order. Now, which is this executive order previously enforced? Let's presume GGO is a statutory law upheld by the Allahabad High Court. But this B3 definition was made prior to that judgment and prior to the independence. So, what were the executive orders? Do we call Governor General orders or do we call any order by the Commander in Chief is to be said to be a executive order? Subject to conditions, rights, properties, resume, we agree. B4, okay, fine. We are not concerned with that. Now, because with regards to the conditions for applicability of the provision of Section 60B of the Indian Easement Act, the Honorable Court in 1997 for SCC 713 held para 9 on the principles contained in Section 60B of the Easement Act. A licensee becomes irrevocable provided the following three conditions are satisfied. Now, what are those three conditions? That the occupier must be a licensee. So now either we are a licensee or we are an old grant. Now this is for the court to decide. This cannot be a discriminative pleading because we will plead as per the general land register that he should have acted upon the license. Now let's say if we were a licensee, not an old grant, We acted upon it, that we constructed a house and executed a work of permanent character and incurred expenses for the execution of the work. So it is submitted that in view of the above laid down laws, the grant in favor of the bungalow owner has become irrevocable. So, do we have anything left now? These are judgments which need to be dug on. These are pleadings which need to be done. Because if we do not challenge the GLR, yes, I know some people are challenging the GLR. It is fraud, it is frivolent, it is malicious. No, let the law come in place. Why is it malicious? Why is it fraud? How can you challenge that admission which you've given, which is subjected to the General Land Register? Please, there are people who are getting up as, particularly from Jhansi, they are becoming consultants, half baked consultants. I don't want people to lose their bungalows after so much of research. So much. Friends, please understand, these are pleadings, and we have to gag the government, Union of India, because they state that we are licensee, they state we are an estate, we are a bungalow, we are a house. GLR was when prepared, GGO is applicable. The GLR by itself speaks old grant. Why didn't it speak grant? Why didn't it speak new grant? CLA rules are speaking of TP Act's applicability. So we have so many things to be done, and we can do it. I know we can do it. I'm very confident we can do it, but we need to get together. Thank you. Good day.